it please the Board, I appear with Mr. Denton Cox for the appellant, Mr. Alexander, King's Counsel, with Mr. Gujador appear for the respondent. In terms of timing, I'm hoping to take slightly under 2 hours, saving myself about 20 minutes or so for reply this afternoon. In terms of housekeeping, I think the first thing you wanted to be reassured is that I have a client. We received a message indicating that you had taken notice of the fact that there was a period when my client had been removed from the register. It's been restored, and I hope you've been sent.
I have seen the papers. Is that a matter of agreement that the company is back on the register?
Absolutely, my Lord.
Yes, well, I won't take up your time on that.
I'm extremely grateful. I hope you will also, somewhat earlier, have received a joint letter indicating that there was a very minor factual error in the statement of facts and issues regarding the question of whether there had been 2 or 1 previous statutory demands. There will be, in due course, some discussion about the status of the ED order, as it's called, the August 2020 order of the Enforcement Directorate of the Indian Ministry of Finance. But we were going to deal with that when I actually get to that bit of the argument, if that's all right with the Board. And we will also need permission to run, as one of our arguments, our challenge to the decision by the Bankruptcy Court to make an immediate winding up order, which was not a point taken in the Court of Appeal in Mauritius. But again, subject to the Board, I was going to deal with that when I get to that point in the argument, rather than dealing with it at the very beginning, sort of in isolation.
We will hear that matter day by day essay, if that's appropriate. One thing I think the Board would welcome, having regard to the impenetrability of the Enforcement Directorate order and the difficulty in working out from the affidavits precisely the nature of the transaction, initially with Galleon and then with Standard Chartered. If you're able to give the Board an overview of the commercial skeleton, at least, of the transactions in question.
Yeah.
What was Katra's role in this?
Right.
What was the role of the other body?
Can I might as well do that straight off.
Yes.
And the best place, if you want a sort of a clear introduction, is actually about paragraphs 41 to 45 of the tribunal, the arbitral tribunal's award. And the very short answer is that in about 2006, there was a block of shares in this bank, TMB, that were held by a group that was known as the Sterling Group. And there are strict rules under Indian exchange control about blocks of shares being held by foreign investors. The approval of the Reserve Bank of India is required for holdings of more than 5% by a foreign investor. The Reserve Bank of India did not approve the holding. It regarded the sterling shares, as they were called, as being a block that was in substance held, a block of more than 5% that was held by foreign investors. And the short of it is that Katra acquired an option to acquire that block, and it needed financing in order to exercise that option. And it was through that option to acquire, I think initially a 33-ish% block, and then, so as I understand the position from, as I say, the arbitration award, Katra acquires an option to acquire about 33% of TMB, and it actually acquires, as owner, about 17%. And it's in relation to the exercise of the option to acquire, the acquisition of the option to acquire, that it takes the loan from Galleon initially, which was for 30 million in, I think, the earlier part of 2006. And that was a very short-term loan. And the loan from SCB was taken in order essentially to refinance the acquisition of the option to acquire the shares in TMB. And so the option to acquire that block puts Katra in the position of being able to put into the escrow account held by SCB Mumbai the share certificates and blank share transfer forms in relation to roughly 40% of the issued share capital of TMB.
In whose name would the shares be? Some of the shares would be in the name of Katra.
Yes, I think 10,000 and something.
Yeah, what about the rest?
That I can take instructions, but I'm not aware that it's in the papers.
No.
If it would help, not now, but I can take instructions, then perhaps discuss with my learned friend whether anybody has any concerns about me giving evidence, so to speak, as to what...
It may not matter. It was just trying to understand what had happened.
No,
it wasn't the most straightforward of deals, at least its presentation in the papers.
Yeah. My learned junior points out that from para 41 of the arbitral award, it could be inferred that the shares remained registered in the name of the Sterling Group, but that share transfer forms, blank share transfer forms, had been executed by them. That I think, actually, on reflection, probably is quite a good inference to draw.
Well, I was wondering if that's what in fact had happened.
Yeah.
Yes.
Because the Enforcement Directorate order talks about Katra getting a fee, an arranger's fee.
Yes.
Which is not really how one would think of it, having bought the shares.
Okay, sorry. So I've only described the sort of the first half of it. The idea then, and this is where Corsair comes in, the idea is that the shares that then sit in the escrow account...
And was that more than the 17%?
That's in total 40% sitting in the escrow account. The idea, the whole purpose of the project is to market those shares to foreign investors in blocks of less than 5%, so that RBI, Reserve Bank of India approval, can be obtained. So the idea is that the escrow account is essentially a holding account, it's a sort of warehouse. And Corsair is then meant to be placing the shares with overseas investors. And one sees, again, from the arbitration award, that the reason SCB is interested is that it hopes that Indian regulatory regime may relax, enabling SCB in due course to become a substantial shareholder in TMB. So SCB is in the position of being a lender to Katra in order to refinance the acquisition of the option. It's the escrow agent sitting on, so, it's got the keys to the warehouse, so that the shares are held with a view to being placed with foreign investors, and it is also a proposed investor. So that was the point of the whole deal, essentially.
So the galleon loan was to finance the acquisition of the shares. Or, because I think you said to acquire the option.
It would appear from, I think, paragraph 42 and 43 of the arbitration award that the galleon loan was actually to acquire and retain the acquisition of the option rather than buying the shares. I think the shares are worth very considerably more than 30 million, the 40% block.
So who owns, so it's an option to acquire the shares?
Yes.
So whoever owns the shares still owns the shares until the option is exercised.
As I understand.
So that's the Sterling Group.
Yeah, that's the sense.
So was it the Sterling Group that lodged the shares with the escrow agent?
As a matter of mechanics, I don't know the answer to that, and again, I can try and find out if it would be of assistance.
Right.
But as I say, I'm working from what's there in the file.
What's the page number, please?
So it's paragraph
41.
Page 104 to 106, and it's really paragraphs 41 to 48, 49 of the award that gives you the most sort of condensed, coherent, potted history of what happened and what the commercial point of the whole thing was.
Thank you.
And Katra then acquired 10,000 shares in his own name.
Yes.
It could have obtained RBI permission to do so, is that right?
It could have obtained RBI permission to do so. Yes. Yes,
and therefore it could have been lawful if they had sought and obtained permission to do so.
Yes, I don't think that the acquisition by Katra of its shares is a sort of a particularly material part of this, because that was actually financed by a loan that was repaid. Right. The loan that wasn't, though you may have seen reference to two loans. There's the loan of 20 million, which has been part repaid, such that I think only 15 million is now outstanding by way of capital principal. Yes. And there was a separate loan of 13.6 million, I think, for the acquisition. Of
13.6 million is repaid, as I understand it.
And that was for the shares that were actually bought.
So when one's thinking about unlawful security, one is only thinking about the 121,000 shares.
Yes.
Not exactly. The 10,000 shares.
No, that's right.
And there was absolutely no impediment to Katra seeking and obtaining RBI authority in relation to those shares either.
In relation to the sort of the shares in the escrow account. Well, the shares in the escrow account were held by SCB Mumbai, so it would have been logical for SCB Mumbai to be making application.
Could Katra have done so themselves?
I don't know. I can try and find out.
And what would have prevented them from doing so? I mean, what on the evidence would have prevented them seeking authority?
I don't know. Could I, with that...
The simple fact of the matter is, it's being suggested that these securities could have been lawful if somebody had actually applied and obtained permission.
Yeah.
And you don't dissent from that.
No.
At some stage, you'll help me by explaining whether it's part of your case that the option itself was unlawful, as opposed to the securities for the lending.
It has not been part of our case to say that the acquisition by Katra of the option to acquire the shares is unlawful, no. The unlawfulness, we're not, in a sense, making our own allegations of unlawfulness. We are simply relying on the findings of unlawfulness that have been made in the show cause notice of 2014 and in the Enforcement Directorate's order of 2020.
But that only amounts to, in the event, as things have turned out, somebody has taken the view that it's unlawful.
Indeed.
But if people had sought to obtain permission, then it would have been lawful.
Yes, if it had been sought and it had been granted, yes. But I mean, I don't want to get too far ahead of myself, but in a sense, one of the points on unlawfulness is going to be the fact that the facility agreement positively required as a contractual term that this security by way of depositing the blank share transfers and the share certificates in the escrow account would happen, and that the title deeds to the land, the 62 acres of land in Bangalore, which you've read about, would be deposited, neither of which is conditional upon prior RBI approval. So on the face of the contract, there are binding contractual obligations to provide these elements, which are described as security. Whether they are or aren't, we can debate. But they are described as security, and they are unconditional contractual obligations under the facility agreement. In the events which have happened, prior approval has not been obtained, and there have been findings of unlawfulness, and that's the context in which we advance our argument. Could I then, what we intend to do is more or less to follow the sequence in our written case. We will deal first with the question of whether or not there is a bona fide dispute on substantial grounds that the debt is owed. Within that, we will deal as a sub-issue with the question of whether or not the Court of Appeal was right to refuse the application to admit the Enforcement Directorate's order of 2020. So that will be the first and by far the larger part of our oral submissions. The second issue we propose to address is whether the statutory demand ought to have been set aside on other grounds, namely the fact that the share certificates, the blank share transfer forms and the title deeds to the land in India were being held as security, collateral, whatever one may call it, and that was a factor that should have been taken into account and wasn't. And the third point we will address is, if we, as you say, I'm grateful, de bene esse, we'll make our submissions on whether an immediate winding up order should have been made. So, dealing with the first issue, bona fide dispute on substantial grounds, there is a lot of material to cover, and I have quite a few page references to offer you. I was hoping to get through without turning up too many of the documents, because it always breaks up the flow. But just starting with the issue on substantial, a dispute on substantial grounds, the jurisdiction is not in doubt. It's in section 181, subsection 4A of the Insolvency Act 2009. That's in the authorities. One doesn't get much from it. You've probably seen it quoted. It's on page 1200 of the bundle. The court can set aside a statutory demand if there is a substantial dispute whether the alleged debt is owing or due. And there seems, in our submission, not to be any real issue between the parties as to the principles which the Mauritian courts apply when exercising its power under section 181(4)A. The parties have each summarised the law in their own ways. You've seen it, no doubt, in our case at paragraph 36, in the Respondent's case at paragraphs 13 to 17. And the short point, and it's familiar, no doubt, with those who've dealt with insolvency here, the short point is essentially that the court's function when deciding in the context of an application either to wind up or to set aside a statutory demand under this heading, the court's function is not to resolve any dispute as to whether or not the debt is due or owing, but it is rather to determine whether there is a genuine dispute on substantial grounds. That, I think, is not in issue. The only 2 points of detail I would just wish to mention before getting into the facts are these, that in my learned friend's case, I don't ask you to turn it up, but in my learned friend's case, at paragraph 21, 3C, he says that an appellate court is unlikely to overturn a finding at first instance that a debt is not disputed on substantial grounds. And the authority he cites in support of that proposition is Macpherson and Wise, which is at page 1889. Again, I don't ask you to go to that. Could I just leave this thought with you with respect that the decision in Macpherson and Wise does not make any general statement of principle that supports my learned friend's proposition. And if one looks simply at the facts of that case, what was being said was said in the context of an appeal, where the dispute was as to whether there was a credible case on the evidence that the parties had reached an agreement to defer repayment of the debt pending sale of certain property. So the decision that had been taken at first instance was purely a question of whether or not there was a credible argument on the evidence. In that situation, of course, one is well familiar with the idea that an appellate court is reluctant to take a different view from a first instance judgment in relation to the credibility of an argument that goes to questions of evidence. But there is no general proposition that appellate courts are reluctant to find a dispute on substantial grounds if the first instance court hasn't. A fortiori, we would submit where the points essentially turn on matters of law rather than evidence and credibility. The other point I just wanted, a point of detail on the legal context, is simply to respond to another sub-paragraph of Mill and Friend's written case. He says, again, we don't need to go to it, but he says in paragraph 21(5), which is at page 85 in the key documents, he says that the court's ability under the English regime to set aside a statutory demand on other grounds in the personal insolvency context, he says, is not a freestanding ground. He says the jurisdiction to set aside on other grounds is not a freestanding ground, and he cites the decision in Re A Debtor number 1 of 1987. Again, we don't need to go to it, but it's at page 2224. And our response, just so that I don't leave it unanswered, is to say that with respect, my learned friend is wrong. If you look at, and I don't ask to go now, but if you look at what is said on page 2229, between D and F, it is perfectly clear that the other grounds is an entirely independent head of jurisdiction, and indeed it arises precisely in circumstances where there is no dispute on whether or not a debt is due. That's a point that comes up more relevantly when getting to the question of exercise of the jurisdiction on other grounds, but when going through the law, I just thought it's worth mentioning now. Then just very briefly to outline Katra's case on the substantial dispute. The elements that we say go to make up the argument are these. First, that the loan facility with which we are concerned was one part of a wider transaction, which I have attempted to describe to you, which involves the acquisition of rights in relation to this block of shares, their holding in the escrow account, and their onward sale to external investors. So the loan facility is simply one part of a wider transaction, and the different elements in that wider transaction are inextricably linked. Second point is that three elements in the wider transaction were, as we've seen, the delivery to and holding by SCB Mumbai as escrow agent for SCB Mauritius of the share certificates and blank transfer forms in respect of 40% of the issued share capital of TMB, an Indian bank. Second element, the operation by SCB Mumbai as escrow agent for SCB Mauritius of an escrow account. We assume, in fact, 3 escrow accounts for the receipt of the sale proceeds of the shares in TMB as and when they were sold to investors. And the third element with which we are concerned is the delivery to and holding by SCB Mumbai, again as escrow agent for SCB Mauritius, of the title deeds to 62 acres of land in Bangalore, India. So those are 3 critical elements we need to keep in mind. The third building block in our argument on substantial dispute is that the relevant Indian authorities have held that those 3 elements are unlawful as a matter of Indian law and have imposed very significant fines totaling about $12 million on SCB in respect of those breaches. And the fourth point is that the conclusion from all of that is that we will submit that as a matter of Mauritian public policy, the Mauritian courts should not enforce arrangements that are illegal under the laws of a friendly foreign state. In order just to develop those arguments, we were going to follow the course that we have outlined in our written case at paragraph 44, where we identify the 4 stages in the development of the argument. And those 4 stages which I'll now work through are first the evidence of contraventions of Indian law. Secondly, because one of those elements, one of those bits of evidence is the ED order, so the second point I'll address is the Court of Appeal's refusal to admit that in evidence. The third heading will be the reasons why the contraventions of Indian law give rise to a bona fide and substantial dispute as to the debt. And the fourth point, which I can deal with very lightly because Malone & Friend is not running an issue estoppel or raised judicata argument anymore, but we thought there was going to be an argument that the SCB was running, that the arbitration award raised some issue estoppel. And I just want to deal very briefly with why, with respect, Malone & Friend is right not to be running that argument anymore.
Just before you leave that helpful summary, the illegality which you rely upon in point 3,
Yeah.
am I right in thinking from what you said earlier that it's an illegality in performance rather than in inception?
It is an illegality that arises because the contractual obligations under the facility agreement were unqualified, and in the events, they're unqualified in the sense that they weren't conditional on prior RBI approval, and in the events.
Is that what the Indian authorities found, namely that it was simply because they were unconditional obligations, or simply because consent wasn't asked for?
The finding of unlawfulness is based on the fact that there isn't RBI prior approval.
So the findings on which you rely are illegality in performance, as I understand it, although you say that means there's also illegality in inception because there was no conditionality in the facility agreement.
Yeah.
But that's not the finding.
The finding is not that. No, exactly.
Okay.
Sorry.
Thank you.
Short answer is
just before we leave that, but did your client not give a warranty that the arrangements were contained in the agreement were legal under the relevant laws?
It gave a warranty that it was able to perform its obligations. I'll have to remind myself as to the exact terms of the warranty. Can I come back to that, my lord?
Yes, but this is relevant as to whether there is an illegality in inception.
Yes. Yes. Can I come back to that in a moment? I'm grateful.
I'm sorry for pursuing you, but your fourth conclusion is that as a matter of Mauritian public policy, it shouldn't enforce something that is unlawful. And
yes.
It's not seeking to enforce any part of the securities.
Well, that's why one of the building blocks in our argument is that the facility agreement itself is one element in a wider transaction, and all the elements in the wider transaction are inextricably linked with each other. And that is the basis for saying that the Mauritian courts, as a matter of Mauritian public policy, shouldn't enforce this element in that overall transaction.
And so therefore, every single part of the transaction, every single part of it, from 2006 onwards, you're saying was illegal, unlawful?
No, the argument is that Mauritian courts should not enforce, by virtue of Mauritian public policy, transactions which are unlawful. Well, I mean, if they were unlawful under Mauritian law, that would be a different line of argument altogether. The argument here, the only argument we're concerned with, is the extent to which Mauritian law requires the exercise by the courts of Mauritius of a Mauritian public policy not to enforce a transaction which is unlawful under the laws of another jurisdiction. That's the basis upon which...
And have the Indian authorities said this loan is unlawful?
No. The Indian authorities have not said, well, they haven't addressed the loan. in itself at all.
Well, from what you said, in answer to my question, they absolutely haven't said that the facility agreement itself was unlawful.
No, indeed they've not.
Well, they
That's a
haven't focused.
construction which you put on it.
They haven't focused on the actings of any parties which weren't resident in India, as I understand it.
Indeed.
So we don't see any mention of Katra or any mention of SCB Mauritius.
Well, we do see...
Well, in terms of findings of illegality, do we?
in terms of findings of illegality, that is true, because they are only concerned with illegality under Indian law.
Yeah, they'd have no business looking at this agreement, would they?
Indeed, they wouldn't. But what they do, and they do say in terms, and this is one of the errors that the Mauritian courts made, is that the findings are made that the unlawful security that has been identified was given expressly for the purpose of the making of the loan. I mean, it may be convenient.
That really goes without question. I mean, the bank wasn't going to advance this large sum of money without obtaining security.
Exactly so. And that is essentially why we say that the elements in the transaction as a whole are inextricably linked. If I could just turn and deal as rapidly as I can with the first sub-issue under this heading, which is the question of the evidence of breaches of Indian law, and just run through the elements that I think are not controversial. I think we've essentially covered them, that the share certificates and blank transfer forms were deposited with and held in escrow by SCB Mumbai as escrow agent for SCB Mauritius. And we get that from Mr. Subramanian's first witness statement, paragraph 9.5, which is page 10 of the bundle.
Mr. Crowe, I'm just sort of puzzled by that, because if the shares were still owned by the Sterling Group, have they given up? I mean, why would they allow those shares to be held by an escrow agent for the Mauritian, for SCB Mauritius?
From a commercial point of view, as I understand the thinking, but and again, this is an inference from the arbitral award, is that the Reserve Bank of India had held that the sterling block wasn't approved by the RBI, and so sterling couldn't hang on to it. So sterling had to find some way of shedding it.
I see.
And this whole transaction is that vehicle.
Right, thank you.
So share certificates.
So that finding of the RBI was prior to this whole transaction.
Yeah, absolutely.
Yes.
Yeah. That's the sort of that's the prologue, and it's specifically in paragraph 41 of the arbitral award on page 104.
Okay.
So share certificates, blank transfer forms in relation to, I think, 112,151 shares in TMB are deposited with SCB Mumbai.
Sorry, give that number again.
112,151.
That was the shares that were deposited with the certificates and the blank transfer forms with SCB.
That's right. And if you want a reference for that, we'll come to it, but it's in the show cause notice, paragraph 30. Second, SCB Mumbai, as escrow agent for SCB Mauritius, has operated the sale consideration escrow account for the receipt of the sale proceeds of the shares in TMB as they are sold onwards to external investors. And thirdly, the title deeds to 62 acres of land in Bangalore the title deeds have been similarly deposited with and are held by SCB Mumbai as escrow agent for SCB Mauritius. The first element, the first evidence of unlawfulness under Indian law of those three elements is
the bank account in which they were going to hold the proceeds, that was a separate escrow account.
That's right. Yeah. Yes. Exactly. Yes. In fact, the arbitral award tells us there were 3 escrow accounts. There was the escrow account for holding the shares. There was a Indian rupee escrow account, and a US dollar escrow account. So the first piece of evidence of unlawfulness under Indian law is the show cause notice. If you could just turn to that, I will want to turn that up very briefly. It's at page 215 in the bundle. And if you go to page 217, you'll see it's got a large number of addressees, or notices as they are called. Then if you go to page 217, you'll see that noticee 25 is Standard Chartered Bank, Mumbai, and 26 is Mr. Ghosh, the then head of Standard Chartered Bank, Mumbai. And the 2 relevant findings of unlawfulness are in paragraph 13, which is page 222, whereas Standard Chartered Mumbai and Mr. Ghosh, then business head, opened an escrow account in the name of SCB Project Windmill Sale Consideration Escrow Account and another escrow account in the name of SCB Project Windmill Shares Escrow Account, and allowed deposit in the said escrow account totaling a number of rupees. The commas are because of crores and lakhs. I have to say I've always found it difficult to work out exactly how much, but in any event, foreign entities deposit significant sums by way of Indian rupees towards the transfer of shares in TMB. Which
so those are the proceeds of onward sale of the shares?
I think that is correct, yes. Towards the transfer of the shares, which were not permitted for transfer by the Reserve Bank and kept 112,151, that's where I got the number from, in TMB, in the shares escrow account, without any permission of the Reserve Bank of India, and thus had contravened the provisions of Section 6.3b and F of Foreign Exchange Management Act with Regulation 10A. And then at paragraph 16, over the page on page 223, and whereas Standard Chartered Bank Mumbai and Mr. Ghosh have taken custody of title deeds of over 62 acres of land owned by Mr. Vangal and Aerodrama Developments Private Limited, and taken custody of TMB shares as collateral/guarantee, in lieu of which Standard Chartered Mauritius granted a loan of, and the number is 35.4 million because there are other borrowers in relation to this with which you're not concerned, but to 3 foreign entities, Katra Holdings Limited, and then which is the one with which we are concerned. And then in the fourth line, it says, without any special permission from the Reserve Bank of India.
Isn't it? Yes. It's actually lines 2 and 3 on.
Sorry, yes, absolutely. The 20 million is in line 2. That's quite right.
But what is it that they should have got permission for?
One gets that.
You don't really get it from that paragraph, do you?
Well, one gets it. Sorry, one gets it from paragraph 14. Capital account transactions. It sets out section 6, the relevant bits of section 6.3. Well, and one needs
J. Giving
a security.
Yeah.
In respect of a debt, obligation, or other liability.
Yeah.
So it's the unlawfulness is the giving of the security.
Yeah.
Yeah. Okay.
And in relation to the unlawfulness under para 13, you get the relevant statutory provisions of paragraphs 8, 9, and 10 that precede that set out the provisions of the Foreign Exchange Management Act.
again, it's without permission.
Yeah,
Yeah.
exactly. And so there is the finding of contravention there in the 245th line, thus contravened, and then paragraph 23 on page 226. You'll see now, therefore, this is the operative part, now, therefore, TMB, Standard Chartered Bank, and 2, 4, 6, 7 lines down, Mr. Gosh lists all the notices. The notices, so 8 lines down, the notices herein are required to show cause in writing within 30 days from the date of receipt of this notice as to why adjudication proceedings as contemplated under Section 16 of FEMA should not be held against them in the manner as provided under Rule 4 of the rules for the above-mentioned contraventions of the provisions of FEMA 1999 and the regulations issued thereunder. So, and you'll recall from the first instance judgment, the bankruptcy judgment, that the judge there held that this was just a notice and that it didn't make any findings of contravention, and the judgment also says it didn't mention the loan. And in our submission, all those findings were wrong in the bankruptcy court. The show cause notice makes findings of contraventions, it uses the word, and it expressly does refer to the loan that was made, the loan that was granted in relation to the grant of those.
Well, the adjudication proceeding is presumably a proceeding which would or wouldn't lead to a finding of contravention.
The adjudication proceedings would.
Or is it just how long you would be in prison?
The adjudication proceedings decide what penalty to impose.
Was it just penal? I mean, is it just just sentencing?
No, it's not a question of sentencing. The show cause notice of itself, the evidence in front of you is that the decision made in the show cause notice is a decision that there have been contraventions. Of itself, that doesn't have, as I understand it, any legal effect in the sense of visiting a penalty. So the question whether or not adjudication proceedings are then brought will no doubt.
Well, if the adjudication is about liability and not, if you like, contravention and not just sentence, then it's surely the assertion of a case rather than a finding of this, the finding of guilt. If by finding of guilt you mean a finding that has of itself legal consequences, then the show cause notice isn't a finding of guilt, but it is a determination by the relevant authority that there have been contraventions. That's the word it uses 3 times.
It's almost a sort of prima facie case.
Precisely.
Yes.
Because
There was no point.
Paragraph 23 is inviting them to show reasons why adjudication proceedings should not be held.
Yeah.
Yes.
I.e., they come along and say, well, there are other facts or matters of legal construction and so on, which you have not taken into account, which show that we have not committed
And the order did conclude that some of the allegations were not substantiated, not necessarily as regards these notices, but as regards some other notices, he concluded that.
I don't want to get too deeply into the weeds of exactly the legal status of this document. The point that we're making is that Katra is trying to set aside a statutory demand. The question is there a reasonably arguable case that there is unlawfulness as a matter of Indian law, and if so, what are the consequences under Mauritian public policy? In our submission, it is unarguably the case that the show cause notice constituted evidence of breaches of Indian law. It may not have been conclusive, it may not be determinative, it may have been open to subsequent adjudication proceedings, but that isn't the point. The question in front of the bankruptcy court was there a substantial dispute? And in our submission, on the basis of that show cause notice, there plainly was a substantial dispute in relation to lawfulness under Indian law. And I was just going to go very briefly to the judgment in the bankruptcy court. If we could just turn that up, if you're working from the key documents bundle, it's page 154. And the 4 points with which we take issue.
What is it in the ordinary bundle?
In the ordinary bundle.
Well, I'll try.
I don't think the judgments are in the ordinary bundle, are they? I think the judgments are only in the key documents bundle.
They're certainly in the key documents bundle, yeah.
So page 154 of the key documents, line 10. Bearing all the above in mind, the judge says, I note firstly that what the respondent purports to rely on is only a notice, termed a show cause notice issued by the ED upon parties named in the notice, informing them that the authorities might decide to hold adjudication proceedings in connection with the issues raised in the notice. In our submission, that doesn't do justice to what the show cause notice does, because as my Lord Richards points out, it is essentially an indication that the noticees are being given an opportunity to explain why adjudication proceedings should not be brought.
I'm sorry, Mr. Gray, I've just not got the
I'm so
reference.
Sorry.
Page
154.
That's why that was my mistake.
Sorry.
154, yes.
Line 10.
Thank you.
Only a notice. I mean, in form, yes, it's a notice, but it does on its face say these contraventions have been made. Here's your opportunity to tell us why adjudication proceedings should not be brought. And with respect, the judge very significantly underplays it by saying that simply it is only a notice informing parties that the authorities might decide to hold adjudication proceedings. That, in our submission, doesn't properly reflect its nature. And the last 4 lines of that paragraph, it does not constitute any formal charge against the parties, still less any finding of illegality. Well, that, as the exchange we've just had, may be, in a sense, technically true. It's not a determination of unlawfulness, but that wasn't the question in front of the bankruptcy court. The question is, was there a reasonable dispute on substantial grounds that there was unlawfulness? And in our submission, there plainly was. If we go into the next paragraph, the judge says in the 4th line, it is clear that no mention whatsoever, let alone any adverse reference to the loan facility extended to the applicant by the respondent in Mauritius. And that is just factually wrong. We see an express reference to the loan facility in paragraph 16 of the show cause notice. And over the page 155, bottom of page of the page on page 223 of the show cause notice expressly refers to the loan. It doesn't rule on the lawfulness of the loan because the loan is governed by Mauritian law, and the show cause notice is dealing with Indian law. But it certainly does mention the loan, and it's on that basis that we say that the unlawfulness of the elements that the show cause notice is dealing with contaminates the loan itself. And then on page 155, lines 8 and 9, the 2 lines about a third of the way down the page. Further, as has been shown above, the contention of illegality are mere assertions not substantiated by any evidence and do not pass the required threshold of credibility. And again, in our submission, that's just not a fair reflection of what the show cause notice is. The show cause notice is evidence of unlawfulness. It's evidence of a finding, whether it's final or not. It's evidence of a finding by the authority in India of unlawfulness. So if I move on as rapidly as I can, the Court of Appeal upheld the findings of the first instance judge on this point. I don't propose to turn the pages, but if I could refer you, it's again obviously in the same bundle, in the key documents bundle, at page 138 is where the relevant passage starts, and I don't have time to take you through it's the bottom of 137 is where the issue of illegality starts. We would just ask you at leisure to reread that with three thoughts in mind. One is whether the Court of Appeal was actually looking at the right document. Instead of referring to the show cause notice issued by the Ministry of Finance, which is what the document we were relying on, it refers repeatedly to an order of the Reserve Bank of India, which it says has nothing to do with the loan granted by the respondent, SCB. Second point, the Court of Appeal flips in the relevant parts of its judgment pages 138 and 139. It flips between talking about whether or not there is evidence of unlawfulness and talking about whether or not the deposit of share certificates was unlawful. And whether or not the share certificates and the land constituted security. So, with respect, the relevant parts of the judgment muddle up the security issue with the unlawfulness issue.
Wasn't there some debate in the show cause notice as to whether the deposit of the certificates had simply been holding on to them in order to then transfer them to the foreign investors who bought the little blocks, or was it actually as security for the loan?
I'm sorry, the question...
Wasn't there some discussion in the show cause notice and then in the Enforcement Directorate's order as to whether the share certificates had been placed in escrow simply to be handed over then to the purchasers who bought them, or whether they had been put there as security for the...
Yes, I think that's more in the ED, or the 2020 Enforcement Directorate order, not the show cause notice. We can come to that. The other mistake that the Court of Appeal made, finally, just before we leave it, is that they say at page 139, they say, in any event, the allegations of illegality by the appellant were rejected by the arbitral tribunal.
Yes.
And in our submission, that is simply wrong. The arbitral tribunal made no relevant rulings on the elements of unlawfulness with which we are concerned. I don't have time to go through it, but the arbitral award, it's really paragraphs 104 through to about 111 of the arbitral award, which is page 117 onwards, is dealing with allegations of breach by Corsair of its obligations to place the shares with foreign investors, getting the shares out of the escrow account. It's dealing with a case by Katra that there was effectively collusion between Corsair and SCB to acquire control over TMB covertly by misleading the RBI. There were a number of allegations of unlawfulness dealt with by the arbitration tribunal, but not in relation to the 3 points that the show cause notice deals with, not least because the arbitration concerned the escrow agreement, which was the document that had the arbitration agreement in it, and it was not concerned with the facility agreement.
Well, except that you do say, don't you, that as I understand it, you say if the unconditionality in the facility agreement makes it unlawful, how can you in the same breath say there's nothing unlawful in the escrow agreement?
Sorry, I'm not saying there is nothing unlawful in the escrow agreement. All I'm saying is that the Court of Appeal was wrong to say that the arbitration tribunal had rejected the allegations of unlawfulness on which Katra now relies, because the arbitration tribunal was not dealing with the allegations of unlawfulness on which we now rely. There is a short point that, so we've had a look at the show cause notice and how it was dealt with in the courts below.
That's because you're no longer relying on this collusion idea. You're simply relying on the breaches of the Indian law.
Exactly so. Exactly so. In order, I'm still under the head of evidence of breaches of Indian law. The next piece of evidence is the Enforcement Directorate Order of 2020. There are observations in my learned friend's case that suggest that he is challenging whether we're entitled to rely on it. I don't know if he proposes to pursue that, but it is, the ED order is referred to in the statement, the agreed statement of facts and issues. It was included in the index for the reproduced record, which was agreed by the respondent's solicitors. And since a major part of our case is that the courts below, the Court of Appeal below was wrong to exclude it because, in our submission, it is relevant. That's not a point that you can decide without having looked at it. So I was hoping, without being too presumptuous, to proceed on the basis that it having been referred to in the statement of facts and issues, I can take you to it.
I did indicate, I think, that we would look at it day by day, I say.
I'm grateful. The questions...
Clear, Mr. Crowe. In the light, I mean, I understand why you're going to it, but in the light of what you've said about the show cause notice, your position is you don't need the ED order.
Absolutely.
Yes.
Yeah. If I could just very briefly turn a couple of the pages, it's an extremely long document. It starts at page 500 in the bundle. And at page 500, you'll see in box 1, it's an order passed in accordance with the provisions of FEMA. And in box 3, that an appeal against the order shall lie to the appellate tribunal. So it is an adjudication. And if you look at page 503, you'll see that at the top of the page that SCB Mumbai and Mr. Ghosh are respondents to it. It identifies the nature of the contravention at para 2, and you'll see from paragraph 5 that there was representation, legal representation. The findings that we would just draw to your attention, page 650, paragraph 6.54.5, after having held that the SCB project windmill sale consideration escrow account and the shares escrow account, both with SCB Mumbai, qualifies as escrow account escrow arrangement. The next question that arises whether Notice C25, that's SCB Mumbai, was required to take prior permission from RBI for the purpose of opening these escrow accounts. And if we go on to 652, I don't have time to read, but that page makes the findings, and if I could draw your attention to the last paragraph on the page, Notice C25 was therefore well aware that the transactions were undertaken in terms of the escrow and transaction settlement agreement dated 12th of May 2017 required the RBI's approval, and the failure to obtain the same was clearly being done willfully with the intent to avoid scrutiny by regulatory authorities and thereby breach their fiduciary position as escrow agents. These are serious findings against SCB of willful breach.
This is against SCB Mumbai.
Yeah.
This is, refers to an agreement dated the 12th of May 2017.
Yes, that's the escrow agreement.
Is it?
Yes, it was I think, amended.
I mean, I think
Actually, my Junie points out that sorry, I hadn't noticed, 2017 is 2007, which you see from the previous
paragraph.
Yeah, paragraph before, it should be 2007, yeah.
It says the prior permission from RBI was envisaged in the 2007 agreement.
Yeah. And then if we go over to page 653...
There's no breach there referred to as
sorry, the breach is found, so I don't have time to read everything, and I'm sorry if I'm taking it too quickly, but it's at the top of the page, the first 10 or so lines makes the finding of breach, and the reason I took you to the bottom is the finding that the breach was willful. And then at page 653, paragraph 655.
The trouble with this, Mr. Crowe, I'm afraid, is that because it's a very long document and you don't have time to take us to it, we can't understand what on earth it says.
Yes.
Did you present the Court of Appeal with any sort of help as to this deals with lots of transactions, lots of different people? When you were asking the Court of Appeal to look at this, did you present them, for example, with a version where you deleted all the irrelevant stuff so you could actually read it and see what it says?
The exchange in the Court of Appeal is in the bundle. If we can go to page 398. Perhaps confusingly, both counsel on each side, below, but called Mr. Gujardel.
Did you say 398?
398.
Oh, in the main bundle?
Yeah. Yeah, I'm sorry, yes. Yes.
We've been looking at the Court of Appeal judgment in the...
Right, sorry. 398 is the full extent of the court's treatment of the application to admit this document. At the bottom, so line 18 towards the bottom of page 398, counsel for Katra says, "My Lord, before we start, my Lord, I have a motion for leave by the court to adduce fresh evidence, my Lord, that." And the judge cuts in saying, "How can you make that motion for fresh evidence?" Now, there's a procedure for that. This case is how many years old? There's a procedure. If you want to adduce fresh evidence, it must be done beforehand.
What had been presented to the court as this fresh evidence?
Nothing at this moment.
So they hadn't seen the 178 pages?
No.
When did your client first obtain a copy of the 178 pages? They knew about it some months beforehand, but upon what date and why then did they not make it available to the other side?
Well, it was available to the other side. It was addressed to SCB. So actually one of our points is we are being criticized.
Why did they not indicate that they were going to apply to have it admitted as further evidence? There are two questions there.
Yeah.
The first is, when did your client get hold of the document, and why didn't it then make it clear?
The answer to the first question isn't in evidence. All we do know is that my client asked the Enforcement Directorate for a copy in early September. When he got it isn't in evidence, so I can't point you at anything. And the application is made...
September 2020, is that?
In 2020, yes. So the order is made in August. My client finds out about it at some point and asks for a copy in early September, and the hearing of the Court of Appeal is November.
23rd of November.
23rd of November. And the Court of Appeal simply don't allow the application to be made. We go to page 399.
But why spring it on people on the morning of the hearing?
My Lord, the question in our submission is simply whether the Court of Appeal was right to exclude it. It could have been handled differently. But you will see from some of the case law we mention in our case that these things happen. And in at least one other case in Mauritius, the court dealt with it by saying, well, what you should have done is to issue an application, we'll adjourn. and allow you to issue that application, and we can come back and decide whether or not to admit the document. But the court don't do that. What they say is, at the top of page 399, counsel says, my lord, that's the whole issue, my lord, we only got this. There's a finding by the enforcement director in India regarding the whole transaction. No, we don't want to hear evidence from you. So in answer to my Lady Rose's question, there was an attempt at least to start outlining why it was relevant, and the judge says, no, we don't want to hear any evidence from you. Counsel says, no, I'm just saying, and the judge says, all we are saying is that we won't allow you to make any motion to adduce further evidence. Now, when the case is coming on for hearing, my lord, if I may, my lord, we've already decided on that. So you proceed with the appeal. We only got this evidence on Thursday, my lord. And the judge says, we've already ruled on that. You proceed with the hearing. So in our submission, the application wasn't heard and rejected. The court refused to hear it.
But you're asking us to, as it were, say they were wrong to exclude it, it should have been admitted, and to deal with the case on the basis that it's before court. And it must be relevant in any case about whether or not the Court of Appeal was in substance wrong to refuse it, to know whether it had been disclosed to the other side, and the other side had been duly warned that it was going to be relied upon, and if so, what the guts of it said.
There is no evidence in front of, there was no evidence on those points in the Court of Appeal, and we, in front of you, are not trying to introduce new evidence that wasn't in the Court of Appeal.
You're not introducing evidence here that the other side were not taken by ambush.
All we can say, Lord, is that the ED order is addressed to SCB Mumbai.
Yes, but this isn't SCB Mumbai.
No, it's not. It's part of the same group. And in our submission, of course, a different course may have been taken. Maybe it would have been better to have taken a different course. But the question in front of you is whether the Court of Appeal was right not to allow the application even to be made. And in our submission, it wasn't.
I suppose the next question then will be, well, if the application had been made in the light of the circumstances, should they have allowed it in?
Yes.
It would be very much normally a question for them, really, but...
And that, if I can, simply take you to paragraphs 60 to 71 of our case, well, not even take you to it, but that is where we deal with the question of whether or not the material should have been admitted. And we say essentially two things. So it's paragraph 60 to 74 in our written case. And essentially what we say is that the Ladden-Marshall test doesn't apply. We don't have to show any special grounds for admitting new evidence in the Court of Appeal because the dismissal of an application to set aside a statutory demand isn't a disposal of a case on the merits. And therefore special grounds don't have to be shown to adduce new evidence. Alternatively, if we are in Ladden-Marshall grounds and we have to show that special grounds are available, we say that they were because self-evidently the Enforcement Directorate order was issued after the trial, the hearing in the bankruptcy court. So it was a subsequent event. So on that basis, there was in our submission a good reason to admit it. And it contains relevant evidence. The footnotes, I am very short of time, and the footnotes in our case draw to your attention the passages in the Enforcement Directorate order which make the findings of breaches. And so we submit that the Court of Appeal should have allowed the matter in, and when we just saw the passage briefly where the judge said there is a procedure for this in our submission, that isn't in fact the case. There is no fixed procedure in the Mauritian rules for the admission of evidence on appeal, for new evidence on appeal. There are cases, as I say, in which or at least there is at least one reported case where an application was entertained at the hearing without prior notice, and in our submission, the court, at the very least, could and should have said, well, if it is such an important document and it will take time to digest, then the appropriate thing would have been to adjourn, perhaps with consequences, but to adjourn and to direct an application to be made and then in due course considered. But simply not to allow the application to be made in our submission was wrong, and to make that decision on the basis that there was a procedure that should have been followed in our submission is wrong just on the case law. There is no procedure laid down.
How long had the appeal been pending by that time?
This was its second outing, because I don't know if you remember from the Statement of Facts and Issues, the hearing in the Bankruptcy Court was 2017, the judgment in 2017, and then there was a hearing in the Court of Appeal, and I think 2 years later, it came on for hearing in the Court of Appeal initially in March 2018, still before the Enforcement Directorate decision. And after the hearing in March 2018, the Court of Appeal simply didn't give judgment. And come May 2020, over 2 years later, one of the judges in the Court of Appeal who'd heard it had retired. So the whole thing had to be reconvened. So there was then the November 2020 hearing, by which time the Enforcement Directorate order had been issued.
I think your submission is, I think you accept by implication in your submission that this application could only fairly have been entertained as an application to adduce fresh evidence by adjourning the hearing of an appeal which had already been pending for over 2 years. Yeah, okay.
I mean, the odd thing here is that as I read the transcript, the court decided not to allow the application to be made without any knowledge of what it was that you were trying to introduce. It might have been some critical document which had arrived in your hands a minute before the hearing started, but they were not going to hear it.
They specifically shut down counsel and said he wasn't allowed to give evidence, and he said that they, whether that's the lawyers or the lay client, I don't know, he simply said they only got the document on the Thursday. I can't take the evidence further than that.
Yeah. It does seem quite a stark decision at one level. Are you able to say whether or not the document had been given to the court before this as an aid to the motion, or are you saying that the court did this without having seen the document at all?
I don't know. I'm working from the documents which tell me no more than you have, but I'll try and find out if that would be of assistance. Can I try and deal with? I've got an alarming amount to get through, and I just want to cover some important ground. So we've dealt with the evidence of unlawfulness under Indian law. We've dealt with the question of whether or not the Court of Appeal should have allowed in the Enforcement Directorate order, and all I can do, as I say, for the detail, refer you to our written case, which has got all the footnotes. The third point, as a matter of Mauritian public policy, should a finding of Indian law illegality lead to the loan agreement being unenforceable in the Mauritian courts? Now, we quite accept that the loan agreement is governed by Mauritian law. The findings of unlawfulness are made by the Indian authorities in relation to Indian entities. We submit that that should have led the Mauritian courts, as a matter of public policy, not to enforce the loan agreement. And the stages in that, if I can deal with this as rapidly as possible, the stages in this are, first of all, as I foreshadowed, the different elements in the transaction were inextricably linked to each other. Katra had acquired the option to purchase this block of shares. To finance the acquisition, it had taken out the loan. The stated purpose of the loan facility was the acquisition, the refinance of that acquisition.
Of the option.
Of the option. well, I mean, on the face of the loan facility, it says refinancing/acquisition of shares. That's page 19 of the bundle. Acquisition of shares in TMB/refinancing of existing.
But in fact, had the option been exercised at the time of the refinance?
That I can't answer by the evidence that's in front of the court. All we do know is the findings that 112,151 share certificates or share and blank transfer forms have been deposited. So those shares were under the legal control of SCB Mumbai.
By the time of the refinance?
No, by the time all I can say is by the time of the show cause notice.
Well, yeah, of course, but I'm talking about the time that was sometime after the refinance.
Yes,
sure.
I'm afraid the evidence doesn't show exactly how many shares were deposited into the account. But it is a condition of the facility agreement that the 40% are deposited within a fixed period of time, 7 days.
Of the loan agreement?
Yeah, within 7 days of the loan agreement. That's condition, so it's about the sixth bullet point on page 21.
But by the loan agreement, do you mean the facility agreement between these parties? Yes, not the original loan agreement.
No, sorry, no, not the.
So the implication is it hadn't happened by the time of the facility agreement. Otherwise, it wouldn't have provided it to happen in the future.
Whether some of it had happened, I just don't know.
Is that a reasonable inference?
It's equally open to inference that the shares, some of the shares had been deposited, and the requirement was that the full 40% had to be deposited within the 7 days. The conditions in the facility agreement required, as we've seen, page 21, that the title deeds to the land should be deposited, the share certificates to be deposited, and that that SCB Mumbai would act as security agent, as sub-agent for SCB Mauritius. We submit that all of the elements in the transaction, as my Lord Hodge said a moment ago, self-evidently are interconnected in the sense there wouldn't have been the loan without the security. And as I pointed out earlier, SCB entities are participating both as lender, as escrow agent, and as investor. And you'll see that point, for what worth, picked up specifically in the arbitral award, paragraph 48. Page 106. So with that factual context, what should be the approach under Mauritian law?
Before you just go on to the Mauritian law, could I just ask for your comments in the loan agreement on page 20, under covenants, number 7, receipt of all necessary governmental and regulatory approvals and third-party consents if required.
Yeah. It isn't clear from that, to be honest, who's covenanting what. It may be that that's why the show cause notice said that approval was contemplated.
It seems to be a covenant, presumably by the borrower.
The truth is, I'm not sure. I'm not sure I have a submission to make on that.
All right, thank you.
Yes, as Malone Junior points out, any covenant relating to the holding of the shares presumably wouldn't be by Katra, because Katra isn't holding the shares. It's the escrow agent, SCB, is holding the shares. But there it is.
Right.
There is a very big issue as to what the correct approach under Mauritian law is, as a matter of public policy, to the enforcement in Mauritius through the Mauritian courts of contracts which are unlawful as a matter of foreign law. You may have seen from our case that we have cited English case law, Raleigh Brothers, Foster and Driscoll, and some more recent authorities. In response, my learned friend says that the correct approach under Mauritian law is derived from Articles 1131 and 1133 of the Civil Code there, not from English case law. The position that you, I'm afraid, are in is, of course, that the Mauritian courts haven't dealt with this at all in this case. They simply didn't address the question of whether or not, as a matter of Mauritian public policy, the loan was enforceable because of the erroneous approach the courts below took in saying there simply wasn't any evidence of illegality. So they just never got to deal with this point. Now that leaves you, with respect, in the invidious position of having to decide what to do. Do you rule as a matter of substantive Mauritian law as to what the Mauritian approach to foreign illegality should be, absent a judgment from the court below? Our submission is, ultimately, sadly, that the appropriate thing would be, if you're with us, to remit the matter for consideration by the Mauritian courts of the point they haven't grappled with. And the very fact that there is a dispute in this board between my learned friend and I as to whether English case law is relevant or whether French case law and the Civil Code is the exclusive regime, the very fact that there is that disagreement in our submission demonstrates that there is a substantial dispute and that a hearing to set aside a statutory demand is preeminently not the forum for resolving that kind of dispute. It is a vexed problem, and as I say, we've put forward detailed written submissions on the point. I don't have time to expand them, but simply point out a couple of things. My learned friend, as I say, says that the Civil Code of Mauritius provides the answer, and that it all turns on whether or not there is a cause that is illicit. And he says English case law doesn't help. But a few pages later, in his own case, he says that Mauritian courts have looked at English case law on illegality, specifically Patel and Mirza, when dealing with questions of illegality. And he cites, in our submission entirely rightly, a Mauritian decision in a case called Badjo and Marde, which is at page 1426, which in our submission simply illustrates the difficulty in suggesting that there is some sort of bright line between, on the one hand, the Civil Code, and on the other hand, English common law principles of illegality as the appropriate guide to the decision in the Mauritian courts. So there is that a problem as to what the correct approach is as a matter of law. If English law principles were to apply, again, we have explained in our written case why we say that there is a good arguable case. And I don't want to take up too much time in oral argument repeating or expanding on that, but you'll see that we've taken you through decisions, as I say, like Raleigh Brothers and Foster and Driscoll, and then the more recent decisions in Barros Matos, which my Lord Briggs may recall, where you persuaded Mr. Justice Laddie that the common law requires English courts to take notice of the illegality of a contract where it is performed in such a way that one party or both parties commits a wrong. Paragraph 30.
Not that recent, Mr. Crowe.
Well, I'm sure you still remember it.
Come a long way.
Not even with Bernie.
We've also cited a Hong Kong Court of Final Appeal decision called Ryder Industries and Chan, where Lord Collins said that my Lord Briggs had over-persuaded Mr. Justice Laddie, and that...
That's why I've probably forgotten all about it.
and that Mr. Justice Laddie had stated the principle too broadly. But the important point, and this is, so Ryder Industries and Chan, is page 2246. And the really important passages in paragraphs 56 and 57, which are at page 2268, is that Lord Collins does say that there may nevertheless be cases in which there has been a sufficiently serious breach of foreign law which reflects important policies of the foreign state such that the contract is unenforceable. So the question of...
That's at page, give me
2268, paragraphs 56 and 57. And that is, in our submission, a helpful pointer to the approach that may be taken. And it starts looking, to some extent, like where one gets out with Patel and Mirza on illegality as such, where one is making, in a sense, taking an appreciation of the importance of the public policy that has been violated, any countervailing public policies that might be affronted by not upholding the agreement, and as I say in Patel and Mirza, the questions of proportionality as to what the correct approach is.
Is this? I haven't got a date on. I've gone straight to the relevant page.
Right.
What's the date of this authority?
Hang on. 2246. Yes, I'll just find that for you. 2246.
The hearing was the 17th of November 2015.
Thank you very much.
The reasons for the judgment were the 16th of December 2015.
Thank you.
Thank you.
And we then, the reason I particularly emphasise that is that when we are dealing with a case in which you have the Enforcement Directorate order saying there are willful breaches of Indian law, and the Indian regulator has imposed a $12 million fine, if what is part of the mix in deciding as a matter of Mauritian public policy whether to enforce in Mauritius a contract which forms part of a transaction which has unlawful elements of that gravity, that is exactly the kind of consideration that needs to be taken into account in deciding whether or not to enforce the Mauritian law loan. That is preeminently the kind of issue that can't be decided on an application to set aside a statutory demand. By definition, a statutory demand is served in relation to a debt which is due and owing. If there are arguments of public policy which involve making an appreciation of the seriousness of breaches under a foreign law system, that is, in our submission, wholly inappropriate for summary determination in the context of an application to set aside a statutory demand. The other case we've also mentioned in our written argument is the case of Magdayev and Svetkov, which is page 1897. And again, we explained in our written case why we go to that, but it serves again to illustrate the kinds of considerations that certainly the English court takes into account when it is being asked, as a matter of English public policy, whether or not to enforce one agreement when a related but different agreement is unlawful as a matter of foreign law. Now, on the facts, the agreement in that case was upheld, but the issues, and this is most clear from Mrs. Justice Cockrell's judgment in paragraphs 322 to 323, the issues...
Have you got a page number for that?
Yes, sorry, 1956.
Thank you.
The issues included whether the existence in a contract of a term which could only be performed in a manner which was unlawful in the place of performance rendered unenforceable a different obligation the fulfilment of which would not necessarily be unlawful in the place of performance. And the issues were decided by reference to the trial judge's assessment of the overall nature of the agreement, paragraph 334, the likely attitude of the foreign authorities, in that case it was UAE unlawfulness, paragraph 339, and the question of whether sanctions had been imposed by foreign authorities, paragraph 341. Now, all of those considerations would lead in this case, or is certainly strongly militate in favour of the conclusion that a transaction which has as part of its features elements which have been found to be sufficiently serious to incur substantial fines in India would lead to a conclusion that the English court, applying English law principles, would not enforce it. But as I say, we're not here to persuade you that would be the outcome. We're simply having an argument about whether the set-aside application is the right forum for that kind of discussion. And in our submission, self-evidently not so. My learned friend, as I say, he says that articles...
This case was about an arrangement which, in its terms, if implemented, would give rise to foreign law illegality. Is that right?
If everything had been done according to, I mean, if things had been different, it wouldn't have been unlawful. I entirely agree. But in a sense, could I just sort of remind the board with respect of Raleigh Brothers, which is to some extent the sort of starting point of all this. Raleigh Brothers was about importing jute from India to Spain. There was nothing remotely unlawful about importing jute from India to Spain. After the contract was made, a Spanish law was passed saying that the freight for transporting jute could not be above X, and the contractual price was well above X. So the question that was being grappled with was, could the contractual price be recovered in face of local law saying, no, it can't? So there was no question in Raleigh Brothers of there being a contract to pursue an unlawful purpose.
Yet there was a supervening illegality.
There was a supervening illegality. So we say that, I mean, again, I'm not asking you to decide the point, but you can see the argument that what we're saying is, hypothetically, this whole structure could have been implemented lawfully, but in the events which have happened, it hasn't been.
Yeah.
And yet, SCB is seeking not only to hang on to the security, but to recover the debt. And in our submission, there's an argument to be had there, and a 1.5-hour set-aside application for a statute remand, we've already had more than that, and my own friend hasn't even got to his feet yet. An application to set aside a statute remand is simply not the appropriate forum for determining that, and something has gone significantly wrong. We would submit exactly the same outcome would, in fact, be arrived at if my learned friend were right, and the civil code applied. So say he relies on Articles 1131 and 1133, which provide that a contract can't be enforced if it has a cause illicite. And he rightly points out that a cause is illicite if it is prohibited by law, contrary to public morals, or contrary to public policy. So under the Civil Code, the Mauritian court would be faced with exactly the same public policy question about what to do with a contract which, in the events, has resulted in elements of unlawfulness. And in our submission, there would be exactly the same argument under that heading as there would be in the application of English common law principles.
I, at the moment, to give you fair notice, Mr. Crowe, struggle to see what aspect of Mauritian public policy would be offended, having regard to the the Indian authorities' findings in relation to the security if a Mauritian company repays a debt to a Mauritian bank. How does that interfere with comity, and how does it show any disrespect to the Indian authorities? The Indian authorities are holding the security arrangements have been performed in a way that is illegal because permission hasn't been obtained, if they are indeed security arrangements. But the lending of the money to the appellants to implement a contract which could have been implemented legally, where's the offence against Mauritian public policy? Arguably.
Yeah. The offence is precisely in the fact that those security elements which have been found to be unlawful are necessary parts of the transaction under which the loan was advanced in the first place. And the offence, in a sense, is that SCB Mumbai is, and to some extent this bleeds over into the second issue, which is the question of security. SCB Mumbai is at the moment refusing to release the title deeds. It's sitting on the share certificates which were provided by my client because it had the option. It took the loan in order to be able to exercise that option. SCB Mumbai is still hanging on to the share certificates and the title to the land, all of which has been held to be the unlawful elements, and is seeking to recover on the loan. And in our submission, that combination of factors does offend, because it allows, in a sense, SCB overall to salami slice the transaction to its benefit by, on the one hand, offending Indian law, but on the other hand, enforcing under Mauritian law a closely related part of the transaction, in respect to which it has the security which has been held to be unlawful. So there is a fallback argument, and to some extent we would give the same answers. Melanfran says that if the money can't be recovered under the facility agreement,
it could be land security be lawful if, in fact, the land was sold to an Indian national?
Well, the land transaction is the deposit of the title deeds.
Yes, but the next transaction.
The evidence is that SCB hasn't even applied for RBI approval.
Okay, but assume for one moment that whoever initially gave that security was prepared to give that security and wanted to lawfully make it available to satisfy the loan. All they would have to do is sell the land to an Indian national.
That would be a very happy solution, and indeed my client asked for the title deeds to be released against...
You don't have to release the title deeds. You can just enter into an arrangement. They can come along and say, we've advertised it for sale, we now have a purchaser, we'll make proper arrangements to make sure the purchase money goes to the right person, and so on. You don't need the title deeds at that stage. There's been no suggestion from your client to that effect, or from...
My client, there is no evidence that my client has attempted to sell the land. I entirely agree with that. But the fact is that he doesn't have the title deeds. It would be a brave person to offer 62 acres of land, which is worth tens of millions of dollars on the evidence, without the title deeds, knowing that he was in a spat with SCB, not knowing if he could complete. And in circumstances where, as I say, the whole structure was that the title deeds would be deposited, giving SCB a right to create its own security interest, which it hasn't done. And as my junior points out, I mean, it still has that right, but it hasn't applied for Reserve Bank of India approval. And in our submission, it is an offensive situation for SCB to have engineered. I'm not suggesting it was pre-planned, but the situation that has arisen is that there is unlawfulness in relation to what one can loosely call the security elements, but that they are still sitting on those elements whilst at the same time trying to recover on the loan. And in our submission, that does give rise to a sufficient argument. that the elements within the transaction are so closely related that enforcing one while other elements are held unlawful is not appropriate. My learned friend has a fallback argument, which I don't propose to deal with on my feet, and as he pursues it on his feet, he says that if the money couldn't be recovered under the facility agreement, it could be recovered by way of unjust enrichment. In our submission, you can't present a statutory demand in respect of an unproved claim in unjust enrichment, and if a claim in unjust enrichment were brought, then there would be all the arguments akin to those we've already been going through as to whether or not there has been enrichment which it would be unjust for my client to retain the benefit of, because as you've seen, the title deeds have been deposited, the share certificates have been deposited, there have been onward transfers of some of the shares, and there have been partial repayments of capital. The original loan was 20 million. The principal amount claimed under statutory demand is just over 15 million. So there has been partial performance, and as a result, my client can properly say there has not been a total failure of basis within the taxonomy of unjust enrichment, and my client can say that he's changed his position.
But you hardly need to go that far. I mean, if as you say, you can't serve a statutory demand based on an unestablished claim of unjust enrichment, that's the end of the matter.
Yeah, indeed. So the final point that our written case deals with is whether the arbitral award raises any res judicata. We submit that it doesn't, and our case in that regard is set out, our argument is set out in our written case, and I don't think I need to expand it. It's paragraphs 94 to 103. In our submission, it is quite clear that the arbitral award is dealing with different issues, and there is neither res judicata nor any relevance in any broad sense. I'm going to have to deal extremely briefly with the other two issues. But to some substantial extent, the context having already been set out, that won't be problematic. So the second main issue is whether the court below should have set aside the statutory demand on other grounds. And the jurisdiction for that is section 181, subsection 4C, again, page 1200 in the bundle in front of you. We submit that the courts should have held that the circumstances of the case are such that there are sufficiently other grounds for setting aside the statutory demand, even if the court were right in reaching the conclusion that there was no substantial dispute as to the existence of the debt. The arguments in the courts below focused more on a sort of status, a locus standi question as to whether or not a secured creditor is entitled to present a statutory demand, and so the result of that is that the courts below didn't really consider the extent to which SCB Mauritius shouldn't be allowed to pursue the statutory demand in circumstances where it is still sitting on, as I say, security, which it is refusing to release, but also not enforcing. There has been some debate, and there was quite a lot more in the courts below, as to whether or not security is the right word for the title deeds and for the shares that were held in the escrow account. The documents use a variety of different words. The materials are referred to as security, in some places as collateral, in others as a pledge, as a lien. As a matter of language classification, in our submission, it doesn't particularly matter. The facts are clear, namely that the title deeds were held and the share certificates and the blank transfer forms were held. And it is in that context that one then has to consider, well, how does that impact on the court's exercise of its discretion in section 1814C. We've already advanced to you the propositions that these elements in the overall transaction were required by contract. The deposit of the title deeds, the deposit of the shares, and the blank transfer forms were specifically required as conditions of the loan. We are not saying that simply because they are held by SCB Mumbai, therefore the statutory demand must automatically be set aside. My learned friend's case, paragraph 47, denies an argument we're not advancing.
But that is the argument that was advanced below, isn't it?
The argument that was advanced below was essentially that SCB Mauritius is a secured creditor in a technical sense and therefore can't present.
But was any separate other grounds argument advanced? Or is that arising for the first time here?
It's the arguments on section 1814C. I don't have time to go to them, but they are dealt with in our written submissions in the bankruptcy court at paragraphs 17 and 18, which is page 320. And in our Court of Appeal skeleton, as I say, I'm very afraid I don't have time to go to this, but in our Court of Appeal skeleton, paragraphs 18 and 19.
You have a page number for it?
348.
348.
Yeah.
Thank you.
So what we do say is that irrespective of whether Katra was itself, as the company, the registered holder of the land or the registered owner of the shares, and irrespective of whether it was technically a secured creditor, the existence of the unrealized assets under the legal control of SCB, and the fact that SCB was refusing either to release or to enforce any security interest in relation to them were plainly material factors which the court below should have taken into consideration. They were not. One looks in vain in the judgments below. It's clear that the first instance judgment, pages 149 to 150, in the core bundle, the core documents bundle. The first instance judgment was only taking into account the question whether there was a formal bar to a secured creditor presenting a statutory demand. There was no exercise of the discretion under section 1814C. The Court of Appeal, in our submission, again, doesn't deal with the discretionary point. It dismissed the ground of appeal in relation to the relevance of security, really on two bases. It said that the judge didn't decide that the security was worthless, but did decide that even if there was, even if Standard Chartered was a secured creditor, it wasn't precluded from presenting a statutory demand. As I say, in our submission, if you turn the pages between pages 134 and 137, it's very unclear whether it is dealing with the question of the existence of security, the significance of security, or the question whether there is a substantial dispute about the existence of the debt. It flips between one or the other, and in our submission pages 134 to 137 demonstrate a confusion of thought and, most significantly, a failure to engage with the question whether or not the assets which are held by SCB Mumbai. So I'm reminded that the whole section in the Court of Appeal judgment starts at page 128. The confusion, I think, as I submit, is most relevant in 134 to 137. So essentially, what we submit is there is just an absence of consideration of an important jurisdiction and a failure to take into account the significance of these assets which, as I say, are factually held by SCB Mumbai, haven't been released, but also haven't been enforced. And that simply wasn't taken into account. The last
So
point,
what are you suggesting we do about that?
we submit that this is another point that is likely to lead this court to the view that the judgments below can't stand, and that the matter needs to be remitted for proper consideration of the material in the courts in Mauritius.
I mean, can I ask you just 2 points about this? I mean, first of all, given the breaches of Indian law to which you've drawn attention, it's not at all clear to me that SCB is in a position to enforce this security.
It isn't clear. All we do know is they've chosen not to apply for RBI approval. The finding of unlawfulness is the absence of RBI approval. SCB has told us they haven't asked for the approval, so we're in a rather odd...
We don't know whether they'd get it.
No, we don't. No, we don't know whether they'd get it. No,
We're talking about different approvals, aren't we? The complaint in India is that this escrow account has been set up and that the title deeds and the share certificates are in it. You're saying, there hasn't been an application for approval to realise the security constituted by them being there.
Well, I think it's anterior to that, actually, because I think that our RBI consent was required for the creation of the security over the land, not just its realisation, but because the land was one of the owners was a body corporate.
Yeah. Exactly.
Consent for the creation was required. So that's one point I wanted to raise, Mr. Crowe. The other point is this. What is the evidence before the court as to the value of the security?
The evidence that was in front of the bankruptcy court was in exactly. So could I give you just a string of references?
Yes.
So there's an affidavit of Ms. Hubert, paragraph 29b, which is page 88, and the second affidavit of Mr. Subramanian, paragraph 14.3, which is page 232, and he says the value of the land was $38 million. SCB says that's just assertion, but that was the evidence. Okay. As to the shares, the evidence in front of the court was that the value of the shares held was $117 million. That again is Subramanian 2, paragraph 19, which is page 234. So I think we say in our written case that our evidence, I'm not suggesting it was uncontested, but the evidence was that the combined worth was about 149 million. Lastly, very quickly, immediate winding up order. You've kindly indicated that you will hear the argument de bene esse. We submit that permission to run it should be granted. We say it's a point of law on which no further evidence is required. SCB Mauritius asked the bankruptcy court to make the winding up order on the basis of the evidence before the court. Our case is that on the evidence before the bankruptcy court, the order should not have been made. Nobody is suggesting that new evidence or different evidence, no one is suggesting that new evidence needs to be adduced now, nor that any different evidence would have been adduced in the bankruptcy court if this point had been taken. The argument wasn't run in the Court of Appeal, but the argument is being advanced now, and as we submit, it is, as I say, a point of law, no new evidence, and it is a point of law, if one may add, which arises in the context of an order which, if it was properly made, clearly brings about the termination of the company's corporate existence, and we would submit that the gravity of the consequences of allowing the winding up order to stand should be taken into account. We would thirdly just mention that the winding up has been stayed throughout. So overturning the winding up order would not involve reversing any transactions or displacing any office holder. And the final point, just on permission to run the point, is that SCB has known since August 2021 that we wish to run this point. It was identified by Mr. Koenig in the affidavit in support of the application for permission to appeal at paragraph 16Q, page 498. And as it happens, SCB did not object to the grant of conditional permission to appeal on the basis of that application, which appears from page 682. So those are the reasons we would ask you to hear it. On the substantive point, plainly, the Bankruptcy Court has jurisdiction to make an immediate winding up order. It has that jurisdiction under section 1816A2 of the Insolvency Act 2009, which is page 1201. And so we need to show that the court below made an error of principle or failed to take into account material relevant considerations or exercised its discretion on the basis of a mistake as to the evidence, or, in the words of one of my learned friends' authorities, Alltrans and CVA Holdings, we may show that the court below gave far too much weight to particular considerations. Far too much weight.
But was the court asked to adjourn to permit the debt to be paid?
The position...
I mean, it's all very well saying, well, you know, the court didn't consider the right matters and so on and so forth, but if it wasn't being asked to exercise the discretion not to make an immediate winding up order, how do you get there?
Well, the matter arose, I think, in final written submission.
Yeah, exactly.
So that you didn't have the opportunity.
Exactly. That's one of the factors, is that the witness statement of Mr. Stock in support of resisting our application to set aside the statutory demand, Mr. Stock said in terms that a petition would have to follow, and that's his paragraph 8, page 243. It is entirely true that the Uber affidavit had said that the creditor would be asking for winding up. But the outcome is that, at least on the material available at the oral hearing in the Bankruptcy Court, SCB's position had been equivocal on the papers. Secondly, there was no oral submission by SCB in the Bankruptcy Court asking for a winding up order, and therefore no oral response from us. The position we took was that because of the progress of the unlawfulness proceedings in India, the appropriate thing to do was to adjourn and await the outcome in India of the proceedings there, because that would then inform, we would submit, the Mauritian courts in deciding what to do.
Mr. Cray, what I would be interested to know, and I think I would have been interested to know if I'd been the judge in the Bankruptcy Court, is something about the company other than it owes $17 or $16 million to Standard Chartered Bank. I mean, does it have assets? Does it have other creditors? Do we know anything about the attitude of the other creditors? That's the sort of material one would want to look at to see whether there was any point in allowing matters to proceed by way of a winding up petition and so on.
Yes. So the answer to your question is that because I can't answer this. The fact is, there being no unequivocal request for winding up at the Bankruptcy Court, that wasn't front and centre of the company's evidence. Since then, there has been an application to stay the winding up, or rescind the order. And there is evidence in support of that that does identify other assets of Katra. And I'm just trying to find my reference to that. Yes, so in the bundle at page 696, paragraph 5 of the petition to stay or rescind the winding up order suggests that Katra has a balance sheet surplus of 36 million, and it has other assets which include shares in a company you've not heard anything about, which I'm just trying to remind myself the name of.
Yes, it's Kerala Ayurveda Limited, a company listed on the London Stock Exchange, which is in the business of providing Ayurveda herbal medicines and dietary supplements and other services.
So there was evidence of other assets. I think my line friend has suggested that this is a company that has no business. It has other investments. There's no evidence of its trading.
But
Sorry.
I mean, that's astonishing that this company will be allowed twice to be rendered defunct.
Lord, it is a matter of surprise whether that is simply a matter of administrative oversight of not having. There is no, I think.
We don't know.
There it is. It's a peculiarity, but the position we're simply in.
What we do, I think what this does tell us is that the bank is the only creditor, isn't that right?
I think that may be right. I'm not sure.
Yes.
But if I could just, in a few moments, sort of wrap up where we say the court below went wrong in relation to this. And one just needs to look very briefly at the way it was dealt with in the first instance judgment, right at the very end of the judgment. So it's page 155 in the key documents bundle. And it's the last 3 lines on page 155, where the judge says, I therefore find that the application to set aside statutory remand can't succeed. And then she goes on, in the absence of any substantial dispute about the existence of the debt or a counterclaim set off or cross demand, I will proceed to make an order under section 1816A of the Act. That's the immediate winding up order. I take note that the debt is outstanding for over 7 years, since November 2000.
Sorry, Mr. Crowe. Sorry, where are we? Oh, I see. Over the page now. Yes, I've got it.
Last 3 lines.
Sorry. Yes.
Of 155. I'm sorry, I was taking it too quickly.
Yep.
The last 3 lines. So, refuse the application to set aside the statutory remand. In the absence of substantial dispute about the existence of the debt, I will proceed to make an order. And that, in our submission, shows in itself a logical flaw because it's a failure to take into account any other factors.
Well, she takes into account the debt's been outstanding for over 7 years.
No, sorry.
And repayment has been constantly opposed.
Sorry.
No intention to pay the debt if granted.
I was going to get onto that. It's the failure to take into account the factors that we say should have been taken into account in relation to section 1814.
Yes, I mean, you say there's no evidence that the bankruptcy court considered 1814 at all.
That's right. And the weight that was then given to the factors that are identified in our submission was misconceived. She says, first, I take note that debt was outstanding for over 7 years, since November 2009. Well, there are 2 points on that. It's been outstanding because it's been disputed. And the fact that there has been an extensive period of delay in our submission militates against making an immediate winding up order. If there's already been this much delay, the normal course, the default, is to require a winding up petition to be presented so that it can be advertised. If there are other creditors who wish to support or oppose, they can then have their
There weren't any other creditors.
Well, as I said, I don't know what the evidence is.
Well, the paragraph
I think the
5 of
evidence
page
was
696, to which you referred, says
sorry.
that there is only one creditor.
Lord, that is what the evidence there is. I'm talking about what the bankruptcy court did on the material that was then in front of it.
Yeah.
It is simply saying, because of time, the right thing to do is to make a winding up order. And in our submission, that isn't the right approach. The long period of delay is actually a reason that militates in favour of requiring the normal default process to go ahead, and the judge, with respect, has failed to take into account the fact that the significant delay has been caused because there's a dispute, and she has failed, with respect, to take into account the fact that there were previous demands that were then withdrawn.
But surely we have to approach this on the basis there isn't a bona fide dispute. If there's a bona fide dispute, then the statutory demand is set aside.
Yes.
But you're saying even if it wasn't set aside, the court should have taken into account that there was a bona fide dispute.
Well, no, sorry. The court should have taken... When one says the debt has been outstanding for a long time,
yeah.
What we infer from that is the judge was saying, and therefore it can't be repaid, therefore we've got to press on with the winding up, because the delay itself is evidence of an inability to pay. What we're saying is, OK, we've lost in court on the question of whether there is a substantial dispute, but the reason it hasn't been paid is that there was a dispute. The court has found that it wasn't on substantial grounds, but the fact of non-payment for that period of time was prompted, factually, by the dispute, not by an inability to pay.
So you say there was a dispute about whether there was a substantial dispute or not. But if there is no substantial dispute, then why haven't you paid the debt?
Yeah.
Or why did you, to put it in a slightly contentious way, why did you spend all this time trying to kick up dust saying there was a dispute? It must be because you haven't got the money to pay. Isn't that what she's saying?
Well, I suppose Mr. Crow's answer is they might bona fide have believed there was a dispute. It's like parties who act in breach of contract believing that they're not acting in breach of contract.
Indeed. I mean, the judge is not saying, you know, that the application to set aside the statutory demand was made sort of in bad faith, knowing it was unfounded. The judge is just saying, I'm against you. But there has been a dispute, and so the length of time for which the debt has been outstanding is factually explicable on that basis. So that's the judge's first point.
The purpose of the delay would purely be to allow your client to pay the debt, is that right?
Yes.
Because you turn up at the liquidation and you're prevented from saying there's a substantial dispute about it.
There would be that certainly would be a principal reason for requiring a winding up petition to be presented. But as I say,
the only basis is, in the meantime, your client would pay the debt.
Well, as I say, the decision that's being taken here is being taken in the bankruptcy court, ignorant of what the creditor position is.
Well, that is true then, if I've got the dates right, but
yes.
It's not true now.
That is so. So all I can do is challenge the decision on the basis of the evidence as it stood.
Yes.
That's the nature of the task. When the
Your
judge...
client wouldn't have paid the debt in the meantime.
Well, the fact is, we just don't know whether the company would have been put in funds in order, if it couldn't meet the liabilities from its own cash resources within a short time. We don't know. And one of the bases, as we've seen, we've mentioned it in our written case, one of the bases for not making an immediate winding up order is to see whether there is a real prospect that a third party might put the company in funds. It's one of the New Zealand cases mentioned in our written case. So there doesn't have to be evidence of cash at bank in order to require the default position. And the starting point is that requiring a winding up petition is the default. There has to be the immediate winding up is an exception, and it has to be justified by good grounds. And our submission is that none of these are good grounds for departing from the default position. And just to finish...
Do you say the default position is requiring a petition just by looking at the statute, or do you say that's the practical default position in Mauritius?
That is the position that's been taken in the New Zealand case law, which has a very closely similar regime.
It does. I understand that.
And is followed in Mauritius, and is the relevant case law is cited in our case at paragraph 133 of our written case at page 68.
Thank you.
Would I be right, Mr. Crow, to say from my reading of your case that the company's position was it would repay the bank if the impugned securities were released?
Yes.
And also if guarantees were released?
Yes. Yes.
That's what you've pleaded? Yes.
That is so. There was letters, an offer letter in 2011 is in the bundle saying if you release the title deeds, among other things, to the land, will arrange for repayment. And the position in an submission is not an attractive position for a creditor to take. Is no, we're going to hang on to the title deeds. We're not going to enforce the security. And we're going to pursue repayment.
Well, so where you got to was you said, give us the deeds and we will pay. And they say, no, you pay first and then we'll give you the deeds. So that's not an unfamiliar scenario.
No. So just going back to those few lines of the judgment, we've got the debt outstanding for 7 years. I've addressed you on that. The applicant has consistently opposed the response legal initiatives to recover the debt over a long span of time. Well, again, that's in a sense part of the same point, but it suffers the same fault in disregarding the fact that there has been a bona fide dispute, even if the court has held it's not on substantial grounds. And then the judge goes on, has not shown any intention to pay the debt. Well, that, with respect, ignores the exchange of correspondence my Lady Rose just referred to, where exactly that offer to pay was made. I therefore dismiss the application and forthwith make an order. So in our submission, relevant considerations were not taken into account, and the factors that were taken into account were misconstrued, so to speak, and the immediate winding up order was, in our submission, the wrong thing to do. Can I just briefly make sure that in finishing there's nothing else? I'm conscious that some points have been raised which I said I'd come back to, and I'll try and get some instructions if that is of assistance. But I think unless there's anything else I can assist you with, those are our...
Would I just ask for that page number of the offer again? I'm afraid I just didn't...
It's page 63 in the bundle, and it's then repeated, I think, when it's refused on page 66.
Thank you.
Thank you very much, Mr. Crowe, for your clear submissions. What the board will do is we'll rise now early for lunch and resume at 1:45.
Certainly.